Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. You know, when we begin a divorce case, what ends up happening is there's steps along the way, things that the person who brings the case has to do, that's called the plaintiff, things that the other person, that's the defendant, has to do once they get served with the papers. The general process is you file it with the county clerk. County clerk randomly assigns it to a family court judge within the county. That judge is going to sign a summons, which is an order to take action. He's going to attach that summons to that complaint, send it back to the lawyers. The lawyers are then going to get it to the other side. How are they going to get it to the other side? They're going to have a bailiff bring it to him. They're going to tell him he can come pick it up at the office. They're going to send it certified mail. Somehow, some way, they're going to get him the papers. This video addresses what happens from that point in time. Okay, he's got the papers. She's got them. She was just served. What do we do with them? Well, they have a certain amount of time. Generally, if served within the state of Michigan, 21 days from the time they're served to do something about it. This is typically the time when they will hire a law firm to represent their interests, and that law firm will file an answer, perhaps even a counterclaim, saying that what was said here is not the case. It's not true. We dispute this. In fact, this is what happened. And so it begins the he said, she said of the litigation. What happens, though, if you serve your soon-to-be ex and he or she just refuses to answer? They're not participating in this. They don't feel that your complaint and the allegations therein is worthy of a response. So they don't answer. Well, if they do that, they are running afoul of the court rules that mandate that an answer be provided within a certain amount of time. And there are penalties if they don't answer. The biggest penalty for not answering is that the court can enter a default. A default is something that the court clerk enters, called a clerk's entry of default, and that's entered if you don't file an answer within a certain amount of time. The court clerk's going to enter a default. And what the default means is that you have defaulted in your responsibility to answer the complaint, and therefore you do not get to weigh in on what's going to happen in that litigation. If the litigation, for example, involves the custody of the child, you don't get to have your opinion considered. You don't get to weigh in on it. You don't get your slice of the pie. You don't get any of that because you are in default. And the court will say, if you are in default, you're not even allowed to file stuff. The only thing you can do is ask the default be set aside. Once the default is set aside, then the court will permit you to file responsive pleadings and answers, and if you want to. But make no mistake that the most important thing in this case of yours is going to be that you are heard, that your opinion is also considered, that it's not just what the other side says and the narrative that they create, it's the balance of your side as well. I've never seen a case where somebody said, she threw me out of the house, where the other person says, well, he abandoned us. In other words, there's always two sides to the coin. You don't want the court to only have one side. The court doesn't want one side either. The court wants to hear from both parties so it can render a fair decision. You run that risk by not answering, and you give up the right, at least until the court says otherwise, to participate in that litigation. So it's a very, very dangerous thing for someone to fail to answer the complaint. Now, if you have any questions about that, reach out, and we'll be glad to help you out.